looked at my other thing and I realized it's with Buck and Judge Lubin. So why do I worry about being there on time? So I gave up. I had to come here first. Yeah. Did you get that request I sent?
I did.
No problem.
I want to respond.
Oh, no, no. Just,
It was good. Make some sure even that some grammatical.
well, that's why I said it has not spell check. It's just very rough. So I don't get that red pen. Not that I don't appreciate it, but.
I like it because it's 15 reasons, 9 of these are obviously you can't possibly apply. And the rest are, you know what?
Exactly. No, but I realized it was with Judge Lubin and Buck Blank. So why would I even get there on time? No. But it's Buck, so they'll have to wait for me first.
I'm assuming that one got kicked out and everyone else.
I'm assuming that we won't be there, but I don't know.
Cameras are here. Why can't we be there?
Well, of course, the camera, but I don't know. I'm like, who cares? Hey.
I know, sir. But this is the only reason I assume we're here.
Right, this is
And I guess we'll just break that in half again.
yeah.
Talk about.
Or attendance motion for statement to respond. Attendance.
Her name is Rich.
It's Rich.
I'm not going to sorry.
Chains on his neck.
Okay, Madam Clerk, you may call the case.
Case number 2008 CF-15606, State of Florida versus Casey Marie Anthony.
Okay, will the parties please announce their presence, starting first with the state of Florida.
Linda Drain Garvey for the state.
Jeff Ashton for the state of Florida.
Frank George for the state. And the defense?
Jose Baez on behalf of Casey Marie Anthony.
May it please the court, Brad Bishop on behalf,
Just a second. Defense continue.
Michelle Medina for the defense.
Brad Bishop on behalf of the Justice Administrative Commission.
Okay.
Your Honor, may it please the court, Rachel Fugate on behalf of the Orlando Sentinel. I'm here on the Judicial Administration Commission right now.
Okay. And let the record reflect that the defendant is also present, Ms. Anthony. Okay, we are here on a couple of matters. The first matter is a budget hearing, and there's also been notice for the day the defense requests to require the state to file written responses to defendant's motion. And we're also here on a motion to seal. The first thing I would like to take up, unless y'all have some preference as to the order, is dealing with the request to hire and retain expert witnesses. Mr. Baez?
Yes, sir. I think, Judge, that the proper, well, what might work a little better, if it's entirely up to your preference, Your Honor, is the motion to seal. That way, if there are issues that are run up of the confidential nature, that perhaps we'll at least know how to proceed at that point.
Okay, then we'll take up your motion to seal. You may proceed.
Judge, in our motion, what we're asking the court to do, quite frankly, is something of a normal course. We're certainly not asking the court to reinvent the wheel in any way, shape, or form. I've attached as Exhibit 1 a page 43 from the Justice Administration Commission's Policies and Procedures Manual. Sorry. Policy and Procedure Manual, which states under public records, forms, bills, invoices, documents, correspondence, and contracts submitted to the JAC are public records. However, in limited circumstances, the court can order records to be kept confidential and under seal at the JAC. This is so, I don't want to say it happens frequently because it says in limited circumstances, but it happens often enough for them to put it in their actual Policies and Procedures Manual when dealing with indigent clients. Now, that coupled with looking at the Florida Rules of Criminal Procedure, while there is no rule that directly addresses it on point, I'd like to direct the court's attention to Rule 3.216A, which not only outlines a scenario where an indigent defendant can seal an appointment of an expert, but can also do so in an ex parte fashion. Now, I'm certainly not arguing that we're going to utilize 3.216A at this time, or even that it would come up in the future. I would just point that aspect out to the court, that is an actual rule that has actually made it to the Rules of Criminal Procedure. And by denying the seal this specific request, it could indirectly circumvent Ms. Anthony's right to Rule 3.216. And I say that because, quite frankly, if the media is allowed to ascertain these documents from the JAC, even though we had decided to utilize this rule, it could be circumvented by directly filing a Chapter 119 request. Now, this rule was heavily cited in the Callaway decision, which I have given a copy to the court. And the Callaway decision actually cites Hamilton and looks at the underlying rationale for this rule, and that's basically that it's designed to give an indigent defendant the same protection as afforded a solvent defendant. Now, what our position is, Judge, that equal protection under the law, quite frankly, demands that a person who is indigent receives the same type of justice as someone who is private and endowed. Now, I'd like to briefly address, because I did receive yesterday afternoon Ms. Fugate's response to our motion, and she cites the Miami Herald publishing case, which we've argued numerous times in this case on other issues, which lays out the three-pronged test for sealing documents in the court. At least that is their argument. Now, the first part of the three-pronged test states restricting public access to discovery material is necessary to prevent a serious and imminent threat to the administration of justice. The problem is, we're not talking about discovery. We're talking about something that goes right to the heart of what a defense strategy is, right to the heart of work product, right to the heart of the attorney-client privilege. And it does not address the issue. We're not talking today about discovery. And clearly, this is a clear and present danger to Ms. Anthony's right to a fair trial. Part B, and the second prong to the test, is no alternatives other than the change of venue would protect the defendant's right to a fair trial. Now, there are no other alternatives other than sealing these documents to protect Ms. Anthony's right to defense strategy. The only possible scenario would be if some way the legislature were to designate Ms. Anthony's budget under the public defender's budget, where she's even at a more disadvantage if she were represented by the public defender, because, quite frankly, the media doesn't have access to a current case being handled by the public defender's office. So she's 2 steps behind in the process. Now, Section C, which is the third prong, lays out closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. Our position, Judge, is closure is essential to her right to a fair trial. I can't imagine the floodgates that would open as a result of every time we filed a request with the court for funding for a particular expert, for a specific aspect or experiment that our scientists want to run on this very circumstantial case. It is a circumstantial case that relies heavily on forensic sciences of multiple disciplines. And quite frankly, Judge, the pundits, the tabloid reporters, the leeches, and the pseudo-news media, which have come out on this case, would have a field day just on this issue alone. If I can give Your Honor an example of what this newspaper, the Orlando Sentinel, has utilized the Chapter 119 request for in the past. They've gone so far as to order her commissary records. They've gone so far as to ask how much money she has in her account at the jail. They've also gone out as far as to write stories on different anniversaries and on just normal days, stating that she orders 41 bags of spicy Cajun potato chips, 39 bags of Skittles, and 34 sticks of beef jerky. This is what the Orlando Sentinel is choosing to utilize the Chapter 119 section of the Florida statutes in their quest for the right to know. However, it's the defense's position, and quite clear, and that it lies to the heart of her defense that in order for Ms. Anthony to receive a fair trial, these records must be sealed. And quite frankly, the Orlando Sentinel is going to have to find another way to sell newspapers. And I'll save whatever I have for rebuttal, Ms. Fugate.
I have a few questions.
Yes, sir.
The Supreme Court of Florida in Rogers v. State, which is found at 783 7th 2nd, 980, a 2001 decision of the Florida Supreme Court. That was a case dealing with the defendant tried to secure funds to obtain a PET scan examination. And in order for Rogers to do that, Mr. Rogers needed to show that the test was necessary in a couple other things which are outlined in that opinion by the Florida Supreme Court. That was done in open court through testimony. In another case, LeBron versus State, recently, there was an issue about a PET scan examination in a 3851 proceeding. And the defense in that case was utilizing public funds. It was a CCR case, and they had to come in to justify the necessity for that particular case. What distinction, if any, would this case be as opposed to other cases as to why the defense should be allowed to do that in secrecy rather than in open court?
Well, I think what we're talking about are two different issues where we're asking in this scenario to seal the records of the JAC, whereas if the court should find, and I think this is clearly behind Your Honor's discretion and under that aegis, Judge, that if Your Honor decides this is an issue that must be laid out in the public, the same person who sealed the JAC records could have the power to unseal them. And should there be a scenario or a situation where Your Honor feels that we are asking for something that is out of the ordinary, and I believe the standard is what is reasonable to a proper and necessary defense, as opposed to what might be a luxury, or what is absolutely necessary, which is a higher standard. I think that Your Honor could make that call on any scenario that, of course, the court found was unique. Now, I have, for our second motion, what I've done is I've prepared two different sheets. One that I have given a copy to the Justice Administration Commission, and one that I've submitted to the court. Now, I am fully prepared to give a copy of that to the Justice Administration after Your Honor's reviewing of the document, that whether this specific topic needs to be discussed in open court, it can be, or the second one, depending on the second expert, can be or needs to be, and so on and so forth. So I think the gatekeeper, if you will, as to what should be made public and what should not be is Your Honor. And of course, everything that would come under that, Judge. Now, in looking at all of this, I think the court, and the way our system is set up, is the court can and should be the gatekeeper of number one, ensuring that Ms. Anthony receives a fair trial, and balancing that versus the public's right to know. And that's the way our system's set up for every decision, so therefore I would expect, and I certainly would argue, that that's the way we should proceed on an issue-by-issue basis. Of course, if there is a reason or a rationale that we would argue should be kept private, the court could also entertain something in camera on the record, and then later on it could be hashed out in open court, as does in many cases on many issues that have nothing to do with this type of a scenario, and the same would be as if we were in an actual trial where certain things are held out of the jury's view and then actually has to be redone in front of the jury. I would make a comparable argument and say that those two procedures are parallel.
Okay. One more question, Mr. Baez, before you take your seat. The JAC is a state agency, so they are subject to the requirements of Chapter 119. are there any specific statutory exceptions under 119 that you are relying on, or you're relying on just what you just told me?
I would be relying on my previous arguments, but I would certainly point out their own policies and procedure manual lays out the process for which this must be done, which is coming to the court and specifically asking them to seal them. And I think the defense is more than happy to follow that procedure because we think it's the right one to do.
Thank you, sir.
Thank you, Judge.
The attorney for the Orlando Sentinel has filed a motion to intervene. Any objections to that motion, Mr. Baez?
No objections, Your Honor.
Any objections from the state of Florida?
None, Your Honor.
There being no objections, the motion to intervene will be granted. You may stand and present your argument. Ma'am, you may approach the podium, please.
Thank you, Your Honor. Rachel Fugate for the Orlando Sentinel. In Florida, the right of access to public records is not just recognized in statute, but it's recognized in Florida's Constitution. So it is an important constitutional right. It can, however, be limited, as this court has dealt with many times, the Lewis and McCrary standards of sealing discovery, sealing court records when it's necessary to protect a defendant's fair trial rights. There's also a parallel line of cases that say you can't close public records for policy considerations. So unless there's a specific exemption, a court can't close a public record simply because it might make good policy. So without a specific exemption, and if there are exemptions, and there may be certain exemptions that would protect some of the JAC records, and I'm sure that the JAC attorney can speak on those specific exemptions. And if there are exemptions, a limited work product exemption, then that material should be closed as long as the exemption's in place. But without an exemption, we are left with the Lewis and McCrary standard, which is a very high standard. That closure would be necessary to protect the defendant's fair trial rights, that no alternatives are available, and that closure would be effective. And one of the problems I think we have here is that the request is simply too broad. It asks to seal all Judicial Administration Commission records. We don't know what's in those. We don't know whether the specific information would violate the defendant's fair trial rights. At one point, Mr. Baez said we should take it on an issue-by-issue basis, and if there is specific material that should be closed, then that's exactly what we should do. We should take it on an issue-by-issue basis, specific information, and make a specific argument that this piece of information, instead of just closing everything and then saying, oh, well, if Your Honor decides it could be open later on, you should unseal it, that's the wrong way to do this. It's open until the defendant comes to you and says, here's a precise piece of information that would that might violate my fair trial rights. Then Your Honor could consider that specific information, could look at it in camera, and could make an informed judgment. So at this point, I think it's premature and it's simply too broad. It seeks to seal everything in the hands of the JAC. And I think that the public does have a very important interest in this case. This is a newsworthy case. The public follows this case. The Sentinel covers this case, and they do exercise their constitutional right to access public records. And the public is paying for this defense. And there is information in the JAC records that the public is entitled to. They should know how much they are paying for. So I think to seal all of the JAC records would be an extreme measure that is not warranted under Lewis and McCrary. If there's specific information that might violate Ms. Anthony's fair trial rights, then we should consider that information on a case-by-case basis, but not this blanket closure of all JAC records. I think that's just simply too extreme in this case. And if Your Honor has any questions, I would be happy to answer them.